Good morning, Your Honors, and may it please the Court. Alan Gurr for the appellants, and I would reserve 5 minutes for rebuttal. Does the Constitution impose any meaningful limit upon the legislature's ability to ban guns it doesn't like? The state claims its power here is nearly plenary. It argued that so long as it allows the possession of a single handgun, it can ban all the rest without even implicating the Second Amendment. And even if banning most handguns in America, including all new semi-automatic handguns since 2013, somehow implicates the Second Amendment, the state argues that so long as it has a reason to ban guns, the courts are obligated to defer not only to the legislature's assessment of what is best for society, but to the legislature's assessment of what is constitutional. The court, under this view, doesn't measure the fit between the state's goals and actions to see whether the state has gone too far. We disagree. First, let's make no mistake. The handgun roster law is a gun ban. It does not impose conditions or qualifications on the sale of arms. It delineates which arms can be acquired.
Well, it doesn't prevent a person from being armed. They just can't be armed with the gun they want.
That's correct, and the same problem affected the people in Washington, D.C. and Heller. It's remarkable how similar the handgun roster law functions, how similar that is to the laws that were struck down in Heller.
But Justice Scalia and Heller indicated there are restrictions. It isn't, you don't get home free on it. There are others, and here it's on the basis of safety, as I understand it. That is, you can have a gun, but you can't have an unsafe gun. At least you can't market it until it's been passed by the authorities. Doesn't that make your argument just a little different here?
No, it doesn't. First of all, Your Honor, we don't question the fact that the state can ban the acquisition and indeed the possession of firearms that are unsafe in the sense that they don't operate safely in the manner that a normal person would expect a gun to function. So, for example, we have no challenge in this case, and we never did. We never challenged the requirement for drop testing. We never challenged anything relating to melting points. We never challenged anything relating to firing tests. All the things that relate to a gun's normal expected operation as a consumer product, those are simply not at issue in this case, and we're just not challenging them. However, what Justice Scalia and the majority in Heller rejected was the approach advocated in Justice Breyer's dissent. Justice Breyer offered a cogent, coherent, but ultimately rejected view of how to analyze handgun bans. He reasoned, as the state does here, that we can have a balancing test to see whether or not the state has an interest in prohibiting arms, and the court would then defer to the state's legislative choice in that aspect. Now, what the majority said quite emphatically is that this is actually a categorical test. It held, first of all, that the Second Amendment extends prima facie to all arms, to all arms that are bearable arms, and the state can only ban those which are dangerous and unusual. The court also explained that the Second Amendment protects arms of the kind in common use at the time that are used by people for traditional lawful purposes.
Let me just interject why I think if you go back and look at some of the dispute in Heller, it was that there was a handgun ban. And the notion that, well, even if you can't have a handgun, you can have a long gun, the court clearly rejected that kind of substitution argument. But we don't really have that here, do we? Because there is not do you agree there is not a ban on the sale of handguns in California?
There is a ban on the sale of most handguns in America.
No, I'm talking about California. Is there an absolute ban on handguns?
No, Your Honor. However, what we would say is there is, if the state were to prevail here, there easily could be, and I would explain why.
Okay.
First of all, the state reasons that it can ban all new semi-automatic models introduced since 2013 because they lack micro-stamping. The state posits that there's an interest in having deposited marked shell casings at crime scenes that can then be traced back. Under that theory, the state could ban all revolvers as well, because revolvers don't deposit any shell casings at all. And of course, there are no microstamping guns in existence. And so
Well, the issue is that here you have testimony, and your declaration is quite clear that there's some disagreement about the efficacy of microstamping, but in general, microstamping does not affect the user's ability to fire the gun, does it?
Microstamping is a functional concept. That is, the state requires that guns have a particular function, that is that they stamp shell casings. And there are no guns that perform this function in America, and therefore...
Well, that's because the gun manufacturers have decided at this point they're not going to manufacture guns with those. So isn't your argument really that you see down the road that the number of available models, colors, et cetera, would be on a kind of a continuously shrinking continuum?
We don't see down the road. It's happening now. For example, right now, as we stand here today, there are only 744 models in the database, and of those, 307 are semi-automatics. But we looked at the numbers just last month. If you weed out the similars and the duplicates, there are really actually only 97 semi-automatic handgun models offered for sale today.
So there's not so anyone, you can buy a handgun model, you just can't buy necessarily the model you might want, correct?
Well, sure, and if California told Ford Motor Company that it could only produce Model Ts, and Ford Motor Company said it's not in our interest to maintain the Model T production line anymore, then there would be no Fords in California. When we started this case, there were many thousands.
Well, I mean, when we had, I don't want to use autos as a particularly good analogy because there's not really a constitutional issue, but if you do use autos as an analogy, think of airbags. When airbags were introduced, the auto manufacturer said, oh, no way, I mean, this would cost too much. People aren't going to buy my car because it costs more and it'll cost me, so I don't want to do that. That has a lot of ring to what you're talking about with your clients, although I don't know if it's a fair analogy, as I said, because of the absence of a constitutional issue.
I'm not sure that the airbag analogy would hold, Your Honor, because...
Well, neither would the Model T in that regard.
Well, the Model T, the Model T actually is a good analogy because what we have here is we have gun manufacturers that are forced to maintain separate lines of assembly for California-compliant handguns and handguns where improvements have been made over the time, different sourcing for parts, different manufacturing processes. Even the same model, any minor modification requires submission for retesting, and you can't resubmit for testing again if you now suddenly don't have chamberlet indicators, magazine disconnects, and now microstamping. And the people's right to keep and bear arms should not be held hostage to some dispute between the manufacturers and the state as to whether or not something is feasible. People have the right to access arms of the kind in common use for traditional lawful purposes. That includes, as this court recognized in Fioc, which dealt with the magazine ban, the court in Fioc recognized that semi-automatic handguns are arms of the kind in common use. And in fact, if we look at the ATF manufacturing reports, they're issued every year. They're usually a year behind. But in February, they just came out with the 2014 numbers. 83% of handguns manufactured in the United States are semi-automatics. Only 17% are revolvers. So when California says, we're going to ban the overwhelming majority of these things because we want them designed differently, that is a gun ban. Now, in Heller, I want to, again, draw the comparisons between the law at issue in Heller and also McDonald and the law at issue here. Heller did the same thing D.C. did the same thing in Heller that California does here. They banned guns by banning their acquisition. There were exceptions for certain special people. In D.C., there were exceptions for retired police officers. There were exceptions for private security companies. And there were exceptions for non-residents who came into Washington, D.C. for recreational purposes with their firearms, even though that I don't think ever happened. That was on the books. And also there was grandfathering of the handguns that people had registered and possessed prior to the implementation of the ban in 1976. Chicago followed largely the same framework. But even though those cities had grandfathering and they had exemptions, nonetheless, the Supreme Court, and in fact everybody in the case, could look at that case and those cases and say, It's a handgun ban. You're banning most handguns. People can't go and acquire them. Here, we have a ban.
And it was
on
handguns per se. I mean, that's the way it was
that,
written.
yes, and the court.
And this doesn't ban handguns. People can go out and buy handguns.
So if the state were to ban a category of books, or even just one book, or just one gun, let's suppose there was one gun, and the state, for whatever reason, said, we're going to prohibit this particular gun, go purchase another one. We would say that the right to keep and bear arms has been infringed because there's
But
an
your
interest.
argument is a single gun that the state wouldn't then have to, we wouldn't then have to go into whether it should be strict scrutiny or intermediate analysis. You would just say if there was a single gun, even for safety reasons that you disagreed with, that would be a Second Amendment violation.
Not if I disagreed with, if they were legally correct. That is, it's not what I agree with or even what the state agrees with.
It's that you think are improper safety impositions.
The Constitution tells us that we don't. Look, DC had a stronger case on safety than California does have here. In the DC case in Heller, there was no dispute at all that handguns as a category of objects are associated with a lot of crime. They're associated with accidents. There are social costs to the fact that handguns exist in America, and we didn't dispute that. But the reason the court went with the common use test, which is binding, and nobody has to like it, but it's the Supreme Court. The reason they went with a common use test is because they did not trust courts to engage in balancing tests over specific types of arms or categories of arms. And so the Supreme Court said, we're well aware that there are social costs to this, but the bottom line is that these items are imbued with constitutional protection, and so they cannot be
Well, you
banned.
cannot ban handguns as a category, but then they go on to say in Heller, something we've referenced earlier, that of course one of the conditions is laws imposing conditions and qualifications on the commercial sale. And that's really the heart of what we're arguing about here today, right?
It's the heart of what the case is arguing is their case. We would dispute that this is a condition or qualification on sale any more than Heller was a condition and qualification on the sale of handguns. It wasn't, look, if you are regulating whether someone goes through a background check, if there is a training requirement, if there is a safety test, which California, for example, has a condition and qualification on the sale of handguns. It tests people's knowledge of handgun safety, and it actually teaches people to disregard all the things that it mandates here for handguns. It says don't rely on mechanical indicators and treat every gun as loaded, which everybody, I think, agrees is a good common sense gun safety habit. But here, it's not about where you buy the gun or what conditions attached to purchasing guns. It's the fact that you can't obtain this particular gun at all, unless, of course, you're in a category of special people, which in these categories seem to keep on expanding. As we noted in our Rule 28 letter, now it's widows of law enforcement officers and dependents. This is very far afield from a safety law. This is essentially a desire to restrict what guns are available to people because the state disagrees that people should have certain types of guns. The state thinks guns should function differently.
But doesn't the Second Amendment go to people rather than weapons?
It does.
Your argument keeps talking about these weapons. These weapons don't have a right. It's the person's right.
That's right.
Now, if they ban one gun, one model of one gun, you would say that's a violation because someone out there may want that one gun.
If they banned one book or one movie or one religion that somebody would want to have, and it would not be an answer to say, go read something else, worship another god. The reality is that if people have a right to keep and bear arms, and they do, the Supreme Court has instructed that the availability of some arms doesn't answer the question as to whether or not you have an interest in obtaining the particular arm that's being banned. The state can ban guns if it wants, but it has to show that what they're banning is dangerous and unusual. They have to have something other than, well, we just prefer that it functions differently because in our imagination, we wish that the weapons would be somewhat different. And
Okay, I understand your argument, but tell me how you'd phrase it so that it's going to apply 20 years from now from whatever thing they're bringing up for handguns. How would you phrase it that, I understand your one book argument, but how would you phrase it such that they could actually make any type of an inroad other than safety? Or is safety the only inroad that you can conceive that would be a violation that would not be a violation of the right?
well, I think that we can start with what this court said in Fioc, which I think is useful. It says, we consider, and citing Heller, of course, whether the weapon has uniquely dangerous propensities and whether the weapon is commonly possessed by law-abiding citizens for lawful purposes. Let's unpack that statement. First of all, uniquely dangerous propensities doesn't mean that the gun can hurt or kill somebody, because that's what weapons do. Rather, I think uniquely dangerous propensities in the sense of dangerous and unusual means that it has a function that would not be anticipated, something like a defective handgun that blows up in your hand. Okay.
So you have no objection at all to the actually keeping the game sense and having restrictions on unsafe guns?
We have no objection to laws, and some of the laws we didn't challenge do this. We have no objection to laws that actually try to weed out defective products. We also are not litigating, for example, restrictions on other categories of arms that have a completely different function, explosives, bazookas, machine guns, military weapons. That's not in this case. We're talking about a handgun. Prima facie, Heller tells us, the Second Amendment applies to people's interest in keeping these guns. And then the question is whether or not they're dangerous and unusual, and whether they are, or I suppose would be, commonly possessed by law-abiding citizens.
I didn't want to stop you, but
Sure.
I just wanted you to know that you had about 3 minutes left.
I do, and that's why I was going to wrap up and reserve the rest of my time.
All right.
I suppose we can explore the common use test a little bit more. Obviously, we've briefed on it quite extensively. But you look to the gun's function. You look to see what would people use this for. Semi-automatic handguns, plainly arms of the kind in common use for lawful purposes. This law bans some of the most popular handguns in America. We have evidence on that. And there's really no way to justify that. Respectfully, I reserve the balance of my time. Thanks.
Good morning, Your Honors. Anthony Hochul, Deputy Attorney General for the defendant and appellee. Just right off the bat, to address a couple things brought up by opposing counsel. This idea that the Unsafe Handgun Act is a handgun ban is misplaced and wrong. It's not a handgun ban. The record shows, and the district court found, that hundreds of thousands of handgun transactions occur in California annually. Since this case is filed, there have been, evidence is in the record shows that there have been more than 1 million handgun transactions in California. People buy and sell handguns in California. People possess handguns in California. There are literally hundreds of different makes and models of handguns on the rosters today. My numbers agree with counsel's number. I think last time I checked.
But counsel, if all of a sudden the state of California decided to ban a book, it wouldn't be not a violation of the First Amendment just because we had libraries in California that were full of other books.
So here is why the book analogy fails. Books are not guns. When you're looking at the purpose of a firearm regulation, the central inquiry, really, that Heller tells us at the end of the day is self-defense, whether or not you're able to defend yourself. When it comes to books, it's freedom of speech, freedom of expression, a much broader right that is at issue.
I understand that's why we have a First Amendment and then we have a Second Amendment.
Right.
But I'm not at all persuaded by the idea that just because there's other guns we can buy, California hasn't banned guns. So the question for me here is whether the restrictions that California has placed on these guns effectively bans the guns, and if so, then whether we have to get heightened scrutiny, whether California's got a good reason for doing so. And it seems to me that safety is probably a very, very good reason for banning the gun. So why don't you tell us why these are safe?
First
Or
of all,
why the restrictions that are at issue here are important.
just to back up to address your point about whether there's alternative channels to acquire other firearms, that is relevant in the law of this circuit under Jackson versus County of San Francisco and some other cases. So that is a relevant consideration. And in this case in particular, remarkably perhaps, the plaintiffs in this case have admitted that they already possess handguns that they're able to defend themselves with, and that they're able to purchase still more handguns that are suitable.
So under your theory, could we simply ban all Lugers just because a Colt was available?
Well, it would, frankly, it would depend on the reason that you would ban a particular model.
Well, if we just banned all Lugers, could we do that? But if we didn't ban Colts?
Well, to answer that question, and this goes to your other question, I would stick with the framework that applies here in the Ninth Circuit. And, ultimately, I don't know, you'd have to start at step one of the applicable two-step inquiry that applies in the Ninth Circuit. And that is, does it burden conduct protected by the Second Amendment? And one of the very first things that you ask yourself in that inquiry is, does it fall within one of those presumptively lawful categories?
Third category are conditions and regulations on sale. And if California said no one may sell a Luger in California, would that get us through step one?
If it can be characterized as a condition and qualification.
Well, it clearly is a condition or qualification in the state's view, right?
I want to be careful because counsel has said that, well, if we can call anything a condition and qualification, why not just outlaw the sale of firearms? Well, that's not a condition and qualification. That's an outright prohibition. That's an elimination. That's what happened in Heller. So if you had an across-the-board elimination, it would not be a condition or qualification on the sale.
So let me go back to I think the answer to my question is easy, counsel, but I can't get you to get
It's probably
there.
yes.
Okay.
Yes. The answer to get beyond step one alone, the answer to your question is probably yes.
And getting past step one doesn't mean that the state loses.
No,
it just means it's going to have to satisfy a higher burden.
That's exactly right. If you get beyond step one, beyond the presumptively lawful, and also alternatively in this circuit, at step one you also look to historical evidence of similar regulations. That's an alternative way to win or lose depending on your perspective at step one. But if you get to step two and there is a burden, the question is what level of scrutiny to apply. We know from Heller that rational basis, assuming we're at step two of the inquiry, we know from Heller that rational basis is off the table. But in cases like Chauvin, United States for Chauvin, this circuit, the language is an appropriate level of scrutiny. For the most part, in a lot of the Second Amendment cases that have come down in this circuit, it's been intermediate scrutiny. No case has applied any kind of heightened scrutiny.
Well, let's take intermediate scrutiny.
Strict scrutiny, excuse me.
You had indicated you pretty much agree with Pena's counsel's statement of this decline, and it's something like since 2013, the number of these rostered handguns has declined by just under 50%, 43.5 or something like that. That's a pretty dramatic figure of guns in terms of what is removed from the market in terms of for sale. How do you justify that? Because ultimately, you don't have anybody manufacturing, for example, the micro-stamped guns. At some point, you're going to just slide right off that scale.
I agree with counsel's characterization of the numbers as of, I think, last week when I looked, it was, 744. Okay. I don't agree with their basic premise that the roster is eventually going to decline and turn into zero. I think there's been some expression from the bench about part of the reason for that decline is the manufacturer's choice not to participate in the market in California to the maximum ability that they might otherwise be if they wanted to comply with these regulations.
But maybe you can tell me what the state's position is on the construct. Obviously, it's been emphasized that the Second Amendment is an individual right. It doesn't relate to the gun manufacturer, and yet a lot of the briefing, including yours, talks about the gun manufacturer and the feasibility of the gun manufacturer doing things. So how does the market availability of a class of firearms, in this case handguns, from a manufacturer, how does that interface with the individual's right to be able to choose the handgun they want to defend themselves?
If I understand the question, I mean, in Heller, for example, it was a categorical ban on an entire class of firearms, handguns, and it involved possession and possession in the home. And that's not the situation here at all. It's not a categorical ban on an entire class.
Isn't it a categorical ban on any guns not containing the kinds of security devices that you now want, the MDM, the CLI, the microstamping?
It's not, Your Honor. The Unsafe Handgun Act is focused on, in layman's terms, bringing new handguns to market. So for that reason, it doesn't impact possession. So if you were to own an off-roster handgun,
right, but
there's all sorts of guns that were.
You got to be able to get them into the stream of commerce before you can possess them, and you're going to ban the sale of any gun that doesn't have three things: the microstamping, MDM, and CLI, right?
A new handgun brought to market.
Sure.
You and I could exchange, if you own that gun, you and I could exchange it via private party transfer. And that's what, if we get to intermediate scrutiny, all of these things are well within the legislature's ability to regulate firearms in California. These are all choices that the legislature made, and that are entitled to a great amount of deference. At the intermediate scrutiny, at the analysis, you have the important interests. I think everyone agrees that there's important interests at stake here in terms of public safety, reducing handgun violence, and reducing crime. Looking at the tailoring portion of it, the authority in this circuit is pretty clear, and on this I would refer to the Chauvin case, and also most recently in Peruta, there's a concurrence that Your Honor joined in that was endorsed by the majority, and it goes through that on intermediate scrutiny, the state only needs a regulation that promotes a substantial government interest that would be achieved less effective absent the regulation. It does not need to be the least restrictive means. The fit needs to only be reasonable, not perfect.
Sure. That's just a repetition of heightened or intermediate scrutiny.
But
that means that you're through step one, that you've conceded that the Second Amendment applies.
I'm not conceding the Second Amendment applies here. I said that we might get beyond step one with your hypothetical with the Lugers, but yeah, if we're at step two.
So why in the future, if from this point forward, no guns can be sold in California unless they have the MDM CLI microstamping? At some point, there won't be any inventory that doesn't meet that qualification, right? I mean, there'll be private transfers still. You haven't banned private transfers, but there'll be no sales of guns commercially available unless it's got that.
No, there are guns on the roster that have magazine disconnect mechanisms and chamber load indicators. There are guns on the roster that have those features.
Could I ask you a question on this idea that you can get another book? That seems to me just a little bit slippery of a difficult. And what occurs to me is you can close down a religion because next door there's another church. But there's fundamental constitutional values. So the idea that it's okay to limit guns because there's another gun you can get, it works pretty well here, but you took it to another constitutional right. There would be an upheaval if you said to people, we can limit this church and ban it because you can go to another church next door. Is that really the way we want to analyze this case?
No. My response in terms of books are not guns, as in response to the analogy drawn by opposing counsel. And I understand, and I'm asking you to comment on that part of it. the key to that answer, I think, is what's the purpose of the Second Amendment, which is self-defense, specifically, the ability to possess a handgun in defense of hearth and home, which Heller puts it. So when you're looking at regulations, that's the ultimate interest that's always lurking in the background. When it comes to books, it's a much broader interest.
Yes, that's true.
When it comes to religion, it's a much broader interest but
it's very specific. You can go get a whole bunch of books, but if you really believe in one religion, it isn't satisfactory to go to another church.
Well,
and that's the constitutional right that you can choose your religion.
Right. There's freedom of. We have freedom of religion. That gives us freedom of choice of religion.
Okay.
There's not freedom of choice when it comes to firearms. There's no constitutional right to buy whatever.
Isn't the right in the individual, not in the weapon itself? Isn't it the individual's right in the Second Amendment? There's no gun right. There's a right of individuals to have a gun.
I agree with the sentiment that the Second Amendment generally applies to people, not guns.
Yeah. But even when you do this is supposed to be a safety process that we've argued safety. But there's nothing about this stamping that goes to safety. That goes to the police being able to catch the bad guy and put him in jail. How far, and we've been talking about safety here, but how far can you go outside of safety? To good legitimate reasons, bad guys should be in jail. But it doesn't have anything to do with safety of the gun.
The Unsafe Handgun Act, we know from the legislative history, from the various iterations of the act, that safety, consumer safety, guns not blowing up in your hand, that kind of thing, that's one purpose of the act. Other purposes of the act recognized by at least the California Court of Appeal in the Fiscal decision, I believe, cited in our briefs, and also in the legislative history, are reducing firearm crime and also reducing handgun violence. And the micro-stamping is I would contend, is more focused on those elements of, the purpose is that if a shell casing is ejected, it has some identifying mark on it that can be used to track down the owner.
What's the purpose for the
Let me
MDM?
talk about one other question that bothers me, and that's this one individual who can't get a gun because he only has a left arm. Now he's going to be he can't exercise his Second Amendment right, if I understand the argument correctly, because of this statute.
No, that's not that. I don't think that's his argument. For example, the record shows that he can take that gun and deliver it to the manufacturer and have it switched out with an ambidextrous magazine release. So he is able to have a firearm, and in fact, he, along with, I believe it's a man, I'm not sure, that plaintiff admitted, along with all of the other plaintiffs, that they currently possess a handgun that's suitable for self-defense, and they separately admitted that they have the ability to buy still more handguns that are operable and suitable for self-defense. So that, I don't think that's an issue.
But if in fact a person cannot get on the market, they have a gun which is not considered, has not passed the test because of some physical defect, the Second Amendment would still apply to them, correct?
Yes, I mean the Second Amendment is a constitutional right that's enjoyed by all citizens, except for felons, maybe, and there's some categories.
Okay, all right.
Can you tell me about the MDM?
Yeah, so that's a magazine disconnect mechanism. It's basically a function that prevents a gun from firing when the magazine in the semi-automatic pistol is outside of the firearm.
So the gun can could otherwise be fired if there was a bullet in the chamber.
If it didn't have the
MDM.
Correct. And the idea of that is that in the legislative history shows us lots of firearms accidents occur when people think the gun is empty when it is in fact loaded. People think that if you take the magazine out, the gun is unloaded, and in fact, they're still around in the chamber.
If the purpose of the Second Amendment is to allow people to defend themselves, why would you place that restriction on them when the gun, even if they don't want the magazine in there for other reasons, The gun is at its most useful when it's got the bullet in the chamber. Whereas now the gun can't be used at all.
That's an interesting question, and let me tell you why, because that goes directly to what this lawsuit is about. The plaintiffs, regardless of some of the language that appears in the record, they're not challenging the efficacy of the magazine disconnect mechanism. They're not challenging the efficacy of the chamber load indicator. They're not challenging the efficacy of There's a separate case in California it's a state court case that talks about whether or not microstamping is in fact possible or impossible, those kind of things. Their issue, the way that they have framed this case, is that you're not allowed to require these features on handguns because if you can say that a firearm is in common use, you can't regulate it, basically. So that's why there's not expert testimony in the record about whether or not exactly how MDMs work and whether they're the best way to prevent. We have a disagreement on that, but it's not central to their claim at all.
Because the MDM actually disables the gun.
Well, it disables the gun when the magazine when the gun is not fully complete, so to speak. Right. And the idea for that, in addition to just it's if someone were to happen upon the gun too, not just the actual gun operator, but someone would find the gun, a child or somebody like that would think that it's unloaded when in fact it's loaded. And the chamber load indicator,
But your position continues to be that the consideration of the MDM doesn't even get us through step one. Is that correct? There's no Second Amendment. You're not defending the MDM under heightened scrutiny. You still want to defend the MDM that there's no Second Amendment right at all. Is that correct? Those are two very different arguments.
Right. No. So we think the act in its entirety can survive at step one. But to sort of answer that slightly differently, you're correct that there are various pieces of this legislation that are different and might be analyzed slightly different. That can be broken. Microstamping was sort of the third iteration. MDM and CLI were sort of the second iteration. And the first were the drop safety, the fire safety, and the safety mechanisms, which, by the way, I have a chance to make the record clear on that. The Second Amendment complaint in this case, which is the operative pleading, the relief, this is important, the relief prayed for is an injunction enjoining the entirety of the act, all its provisions, the Unsafe Handgun Act as a whole. So that's why we made it a point in our brief to note, okay, drop safety, fire safety, safety mechanisms, those are abandoned, those are off the table. That was not always the case based on the pleadings in this case. I see that I've got 7 seconds left, so thank you, Your Honors. I'd ask you to affirm the district court's judgment in its entirety.
You have some time.
Thank you, Your Honors. First of all, the reason the relief was framed that way is because we also have a challenge to the fact that handguns fall off the roster, even if they are determined to be not unsafe for lack of a payment that nobody can produce, and that infects the whole roster. We can't rewrite the law. All we can tell the legislature is to try again because there are constitutional defects here. What I'd like to address, though, primarily in this time I have remaining, is why we prevail even under intermediate scrutiny. Let's suppose that this is a scrutiny level case. I know courts tend to gravitate towards that end. And let's suppose even further that even though this law substantially impacts people's ability to obtain handguns for self-defense because it bans most handguns, we would apply intermediate rather than strict scrutiny. The problem the state has is that the law is both under and over inclusive. The fit, which is the judicial function here to determine the constitutionality of the fit, is simply absent. Let's talk about over-inclusiveness. Obviously, this is a law that works to ban most handgun models in America. And if the state wins here today, they could ban all of them because, for whatever reason, there are no micro-stamping semi-automatics, and the micro-stamping rationale allows the prohibition of revolvers as well because revolvers don't eject.
What's your objection to the CLI?
The chamber loaded indicator, when this was enacted, was present on 11% of semi-automatic handgun models per the sponsors of the bill. So just by requiring CLI, you've banned 89% of all handguns.
Right, but that's easily cured, right? This is like putting airbags in cars. You can make the argument that the manufacturers don't want to do it and that there won't be any cars available to us, but we've managed to figure out that accommodation.
Actually not. I mean, the CLI requirement, I believe, for technical reasons, it doesn't apply in rimfire ammunition cases, but also some guns simply will not have a CLI because they won't be, the manufacturers determine that you can't sell the gun if you need to impose that feature. Also,
Why can't they sell it?
Well, suppose if you're designing a product that adding a particular feature makes that product undesirable to somebody or makes
Well, that was the airbags. I mean, but it's still functional, isn't it?
But at the same
You
time,
just don't like it.
Whether we like it or not is beside the point. The fact is that if you're looking at arms of the kind in common use in America, 89% of them that long ago didn't have a CLI. So to ban 89% of all semi-automatic...
Sure, that just gets you through step one.
Okay.
We're now to heightened scrutiny. Tell me why you can't have this. I mean,
Okay,
the drop safety mechanism may have been objected to by manufacturers as well because it required them to reconfigure the gun or make it more expensive, and people might object to that. But
because the answer, Your Honor, is found in the state's handgun safety manual that teaches people not to rely on CLIs. I mean, as a basic common sense gun safety measure, we treat all guns as
not
loaded.
to rely on it at all, or not to rely on it exclusively.
Or to say that always assume a gun is loaded.
If you're always assuming the gun is loaded, then you're disregarding the CLI and the MDM.
Why isn't
That
this belt and
argument I didn't
suspenders?
understand.
Because if you're making the assumption that the gun is loaded because all guns are going to be treated as loaded, then what a particular...
I have an indicator in my car that tells me if I fail to engage my seat belt.
Mm-hmm.
But that shouldn't prevent the state from saying in driver training, always check your seat belt, even if the light's not on in your car. That's just good common sense.
But you don't take reckless action. You don't treat the gun as though we're unloaded unless you've opened it, inspected it, made sure that it's actually unloaded.
Great.
So,
and a CLI might be a nice reminder to check it. If you fail to check it, you're going to go, holy Toledo, I've got, it looks like my CLI indicator is on.
gun accidents happen when people make bad assumptions, and the way we address bad assumptions is not to make any assumptions at all. And
Let
this
me
is
ask you, these three restrictions, in your view, do they rise and fall together? Or is there some basis to look at them individually and that one or more of them might be acceptable, but all of them not?
It depends on the way the court decides the case. If you're looking at it as a means and scrutiny case, then perhaps they don't all necessarily rise and fall together, and the court can treat them differently. What's difficult to know is the interaction between the various features. For example, there are guns that may have CLIs but not MDMs, or the other way around, and the state is narrowing down to only those that have both, and then the micro-stamping on top of it. It's sort of hard to sometimes untangle that. But the rationale here, if we're looking at, if I may finish, I realize I'm over the time, Your Honors, and I'll wrap up, is simply that this is an over-inclusive rule. It reaches far too many guns. It's under-inclusive in the sense that it has all these exemptions for all these special people who are allowed to introduce and obtain unsafe handguns. Your Honors, respectively, we would ask that the court reverse here. Thank you.
If you like our videos, follow, subscribe, like, and share.